Hello and welcome to the Entrant. In today's video, we will be discussing the topic of infancy under section 82 and 83 of the IPC chapter 4 general exceptions. The defense of infancy can be taken when the act is done by an infant who is under 7 years of age. By presumption of law, an infant under the age of 7 is considered to be duly incapax, which means that the child cannot constitute the required mens rea to commit a crime, whereas an infant of 7 years or more is considered to be duly capax, which means that although the child is unknown to the crime but can frame intended mens rea to commit the crime. According to section 82 of the IPC, nothing is an offence which is done by a child under 7 years of age. Thus, a person under 7 years of age is not criminally liable for any offence committed. By virtue of section 83 of IPC, a person under the age of 12 but above the age of 7 is not criminally liable for any offences committed, provided such child has not attained maturity of understanding to know that he ought not to do the act or make the omission. Now, coming to the essentials that are required for the defense of infancy. The first one being act of child under 7 years of age. An act done by a child who is 7 years of age is presumed to be duly incapax by the law. The ability of an offence is absolute if the offender has intended the consequences of his act. Since a child lacks both maturity and understanding for the commission of the crime, therefore, he or she cannot be held liable for the offence committed. The second point is act of child above 7 but below 12 years of age. For the children above 7 years and below the 12 years of age, if they commit a crime, then the incapacity to commit an offence arises only when the child has not attained sufficient maturity or understanding. The test of maturity and understanding is the outcome of the act which he intended to do. Therefore, a child to have the immunity of this section must prove himself or herself to be below 12 years of age. Also, the onus of non-attainment of maturity and understanding has to be specially pleaded and proved. It is not necessary for the prosecution to lead positive evidence to show that an accused person below 12 years of age had arrived at the sufficient maturity of understanding within the meaning of this section. It would be permissible for the court to arrive at the finding even on a consideration of circumstances of that particular case. Coming to the third point, that is the maturity or understanding of the child. A child between 7 to 12 years cannot be convicted of any offence unless it is expressly found that he or she has attained sufficient maturity or understanding. The consequences of the act must show that he or she knew what he or she was doing and was aware of the consequences of his act. Taking the case of Krishna Bhagwan versus State of Bihar, a child stole a necklace and immediately resold it to B. The court in this case held that the fact that the child sold the necklace immediately shows that the child has attained maturity of understanding, as he understood the consequences of stealing a necklace. Coming to the Juvenile Justice Act of 2015. This act was enacted to consolidate and amend the law relating to children and providing proper care, protection, treatment and disposal of matters and their rehabilitation and other matters concerned with juveniles. There is no provision under IPC to extend immunity to the children above 12 years of age, but with the development of child rights, it was realized that children up to 18 years are of tender mind and hence they also deserve immunity. Therefore, Juvenile Justice Act was created, which guaranteed legal protection to children up to 18 years of age, and it focused on reformation of children rather than punishment. Hence, such children who were held liable by special courts for an offence were sent to reformation centres instead of jails. However, in recent amendments of the Act, it has been stated that if a child between 16 to 18 years is guilty of a heinous crime which is punishable with 7 years or more, shall be treated as an adult if the Juvenile Justice Board decides so, and may be tried as a normal offender. Now, coming to the topic of burden of proof. The burden of proof to avail this exception under the IPC lies on the accused or the defendant. The accused needs to prove there existed no mens rea, in this case infancy. Section 105 of the Indian Evidence Act further provides a foundation and states that if any person who wants to avail the exceptions under Chapter 4, they must prove that their case falls within that ambit. The determination of age of a juvenile has always been a very controversial issue. Time and again, with the help of cases, the judiciary has tried to determine the age of a juvenile. In the case of Devkinandan Dhyama versus State of Uttar Pradesh, the court held that for the purpose of determination of age of an accused, the date of birth recorded in school record will be taken into consideration. In the case of Arnit Das versus State of Bihar, the court overruled its previous decision and held that date of claiming of juvenility should be on the date on which the accused is brought before the authority. I hope this video was helpful in understanding the concept of infancy under IPC. For more such videos, stay tuned to this channel. Till then, don't forget to like, share and subscribe to the channel of The Entrant. Thank you.